Singh is a practicing advocate and arbitrator. His area of specialization is construction, engineering, joint venture, mining and commercial law. He is a founder and chairman of Indian branch of Society of Construction Law, UK, and director of India branch of Chartered Institute of Arbitrators, UK. He has done domestic and international arbitrations under the rules of International Chamber of Commerce, ICC, Paris, Singapore International Arbitration Center, SIAC, Japan Commercial Arbitration Association, which is JCAA, UNCITRAL, ICA, DIAC, etc. He has delivered speech in various domestic and international events at Harvard Law School, London, Sao Paulo, Singapore, Kuala Lumpur, Kathmandu, etc. He is accredited tutor of FCIArb, which is Chartered Institute of Arbitrators, UK. He is in the committee of various domestic and international organizations. Apart from being a great lawyer, Mr. Ratan Singh is an arbitrator, and his area of practice and his specializes in arbitration. So over to you, Mr. Ratan Singh, to take it forward from here.
Thank you very much, ma'am. Thank you very much for kind introduction. Good afternoon, everybody. First of all, I must thank the organizers for organizing this talk and having me with you. Today's talk will be basically focused on career in arbitration. So here we are going to cover two aspects broadly. One, how to start your career in arbitration, and second would be how to make your career sustainable. Even if you have already started your career as an arbitration professional, how to better it, how to take it forward. So these are two broad areas which we are going to talk today. Now, before we start with the career in arbitration, let me just give a very brief about what is arbitration. If you see your Arbitration and Conciliation Act, it does not define arbitration. You will not come across definition of arbitration in arbitration legislations in any jurisdiction. Now, what is arbitration? Arbitration is a private dispute resolution mechanism which is conducted in private as per the procedures which parties agree or tribunal decides. Decision of the arbitrator is final and binding. This is the broad definition. I gave you this broad definition. Now I'll request all of you, urge all of you to write definition of arbitration in your own way after today's talk. And keep writing definition of arbitration after every 3 months, sorry. And let us see how your definition changes. More you learn about arbitration, your definition will keep changing. Now, about arbitration, it is said that it is one-stop shop. What does it mean? It means that no second chance. You have to give your best, you have to give your 100% in arbitration, because decision of arbitration tribunals, that is called award, the producer of arbitration. Awards are not challengeable like a decree of court, where you have right of first appeal, second appeal, and you go on. You can file objections to the awards, but the court, while dealing with your objection, will not go into the facts, will not go into the law. Court will be only concerned with two aspects. One, whether there is any violation of due process. or in other words, principles of natural justice, and two, whether there is violation of any public policy, which is again a much larger issue. Now, if it is a one-stop shop and you have to give your 100%, that necessarily means that in arbitration, all the arbitration professionals who are involved, the arbitrators, the arbitration lawyers, the party representatives, must know all the aspects relating to the arbitration. Now, that is why it is called arbitration is as good as the arbitrator, as good as the stakeholders who are involved in that. Now, what is the relevance of arbitration? Why we talk about arbitration? As per a rough estimate, around 70% of domestic commercial disputes are decided through arbitration. And around 100% international commercial disputes are decided through arbitration. Now, question is, can you as a law student or lawyer, practicing lawyer, afford to not consider having arbitration as your career option? And somebody may ask, one may ask that about remuneration. Remuneration is really interesting. The way you are compensated in arbitration is really interesting, in the sense that you are paid well. In domestic arbitration, arbitrators are paid around 2 lakhs, 1.5 lakhs, 2 lakhs, 3 lakhs for 2 hours. Some arbitrators charge more. I sit as arbitrator very often. We charge like this. Now, if you are so far as your arbitration, suppose your arbitration is governed by Schedule 4 and court has constituted a tribunal under Schedule 4. Again, the way Schedule 4 compensates you, it's quite good. It's around 30 lakhs per arbitrator. And in investment arbitration, again, you are compensated well. I'll just give you one example and then we'll move ahead. Couple of years back, we had an investment arbitration by the name of UCOS. It was 50 billion USD award. And the lawyers for the claimants were paid 90 million USD. And the lawyers for respondents were paid 35 million USD. Now, a couple of years back, I was in New York and I was sitting with one senior partner of one of the biggest law firms involved. He said, "Hey, buddy, next month I'll be visiting India." I said, "What is this for, man?" He said, "I'm going for fishing." I said, "What fishing you are talking about?" He said, "Fishing for the assignment as for investment arbitration. India is having a lot of investment arbitrations." Now, if a lawyer sitting in USA, New York, comes for fishing in India, what does it mean? It means that we do not have good number of investment arbitration professionals in India. We have good number of decision makers. We have no dearth of good number of decision makers in India. But when it comes to international commercial arbitration or investment arbitration, we have really dearth of good arbitration professionals. This is where you can look at this. This can be your future. What are the career options? Career options are that you can be arbitrator, you can be arbitration lawyer, you can be in-house arbitration lawyer. Big firms, oil and gas, construction, big organizations, they always have in-house lawyers who are well versed with arbitration. You can work with arbitration institutions as case counsels. Uh, you can work as start your career as tribunal secretaries. In fact, in like HKIC, Hong Kong International Arbitration Center, organizes the the training programs, rather course for tribunal secretary. And if you qualify, you pass this, then you may get assignment as a tribunal secretary. And you are paid well, and you get to learn while working with seasoned arbitration professionals. So these are some of the career options we talked about. Now, question is, who all can become arbitrator? I would say that lawyers can become arbitrators, lawyers can become arbitration lawyers, law students, I mean, chartered accountants, company secretaries, engineers, architects, quantity surveyors, they all sit at arbitration. In fact, if I talk about construction arbitration, which I practice very regularly, the world's topmost names, topmost construction arbitrators are engineers by qualification. They are like, I'll give you one name of Sir Vivian Ramsey. Sir Vivian Ramsey was an engineer turned QC. Now he is chairman of Singapore International Commercial Court. Similarly, Sir Robert Gateskill, he is again very big name, is a QC, but to start with, he was a mechanical engineer. In fact, I still remember I was doing one arbitration in London. It was an arbitration between an Indian company and a Finnish company. And dispute was with regard to supply of a defective machine. So ICC appointed Mr. Gateskill because he was a mechanical engineer turned lawyer. So everybody can become, in fact, these days I see lots of retired bureaucrats opting for this career to sit as arbitrator. Recently, I passed an award last month only in a construction arbitration. It was a high value construction arbitration where I was the chairman, and both my co-arbitrators were retired bureaucrats, and they are doing good job because after their retirement, they took arbitration with all seriousness. They have undergone training programs, they have undergone a lot of accreditation programs, and I have known them, and they have read a lot of literature, books on arbitration. Now, invariably, question is asked, what should one read in order to pursue career as in arbitration? First thing is that you must read Arbitration and Conciliation Act. Now, if you have to read Arbitration and Conciliation Act, you must know that your Arbitration and Conciliation Act is based on ancestral model law brought by United Nations. And this model law has been adopted in various jurisdictions, and most of the trading nations are following this ancestral model law. Result is that there is coherence, there is similarity in the arbitration legislations in different countries. Now, if you really want to understand your Arbitration Act, may I give an example before I move ahead? Today, if you have any issue with interpretation of a particular article of Constitution, what is that you look at? You look at the constitutional debate, that is the legislative history of Constitution. Similarly, if you want to really understand your Arbitration Act properly, you should look at the legislative history of your Arbitration and Conciliation Act, that would be legislative history or travaux piquetrois of ancestral model law. If you understand the legislative history of ancestral model law, you would obviously understand the history and legislative history of your own Arbitration and Conciliation Act. And this travaux, the legislative history, is freely available on the ancestral website. So you can just have a look at this. You will get to see there the positions taken by different countries at the time when this ancestral model law was being deliberated and drafted. Why a particular position was taken by a particular country, why it was not accepted by the working committee, how this entire process happened could be a very interesting insight for all of you. So that is one thing I request all of you to look at. Second thing is CLOUT, C-L-O-U-T. CLOUT is the digest of cases, arbitration cases. The cases which have been decided by different model law jurisdictions. That is again freely available on the ancestral website. So you can get to see how a particular provision of ancestral model law, which you have in your Arbitration and Conciliation Act as well, has been interpreted in different jurisdictions. So that is another right thing to do, I would say. Apart from this, one should look at ancestral rules. What is this ancestral rules? Ancestral rules are the rules which are again brought by UNCITRAL, the United Nations. These are the rules for ad hoc arbitrations. Particularly, it is for ad hoc international commercial arbitrations. In fact, a couple of years back, I was doing one arbitration in Singapore, and I was engaged by a big law firm to represent an Australian company. And the arbitration was being governed in that particular instance by the ancestral rules. So ancestral rules is one thing which will give you a very good insight. Apart from that, you must read the rules of one or two popular arbitration institutions like ICC or CIAC or HKIC or LCIA. Read one or two. Even one will be good enough, because all of them keep updating their rules to align them with the latest developments, global developments. Now, if you know ICC rules, and tomorrow you have to do an arbitration under CIAC rules, you will not find much of a difference, and obviously you will not find much of difficulties in interpreting or understanding CIAC rules. In fact, during this lockdown, I have concluded one emergency arbitration under the rules of JCAA, Japan Commercial Arbitration Association. And this arbitration is seated in Tokyo. We did, in fact, I was asked to talk a bit about online ODR and how through electronic means arbitration is conducted, and particularly during this lockdown, COVID-19 lockdown. I can give you this example. This is a joint venture dispute between one Indian company, biggest auto part manufacturer in India, with one company in Japan. And arbitration had to happen under the rules of JCAA, Japan Commercial Arbitration Association. Now, certain disputes arose, and as a result of which we had to invoke emergency arbitration under the rules of JCAA. They have provision for emergency arbitration. So we invoked that arbitration, and within 2 days, emergency arbitrator was to be appointed and accordingly appointed by JCAA. And within 15 days, this entire emergency arbitration process was to get over. And During those 15 days, we had to make our, we started with the notice of arbitration. Thereafter, we presented the emergency arbitration claim. It was responded by the other side. Documents were exchanged. In fact, we asked for oral hearing, which was declined by the tribunal. Instead, tribunal issued questionnaire, which were filled by both sides. We wanted oral hearing through video conferencing, but everything happened through electronic means. And within 15 days, the decision of emergency arbitrator was out. Now, while doing this, and we found no difficulty at all in conducting that arbitration through electronic means. Yes, in this case, we were not faced with ODR where parties had not agreed for the seat of arbitration or other allied and necessary elements which are required. That can be a different subject matter for different talk and discussion. Now, what I was trying to discuss is that while interpreting JCAA rules, I didn't find any difficulty because it was almost similar to other arbitration institution rules. Similarly, while going through the Japan Arbitration Act, we had no difficulty. It is based on unsettled model law. So you read one sentence, you get to understand the whole section. And the moment you have a look at it, you understand, oh, you know how it works. So that's why I said, knowing unsettled model law and your own act, it is like you are doing mastery over all the legislations throughout the world. Another thing which is very important is soft laws. Soft laws means the law which we were talking about just now were the arbitration legislations, and which essentially gives the legal framework for conduct of any arbitration in a particular jurisdiction. But there are various guidelines which are referred to as the as soft laws. And I'll give you some example. IBA, International Bar Association, has come out with a few very good and very popular guidelines and protocols. In fact, one of them has been incorporated in your Arbitration and Conciliation Act in 2015. If you see your Schedule 5 and Schedule 7, this is basically extracted from IBA guidelines on conflict of interest. So you can imagine the importance of those soft laws. These soft laws are prepared by the best brains in the world, and the people coming from all the legal cultures and legal system, they sit together and thereafter they prepare these guidelines based on the best practices in arbitration. So as I said, IBA guidelines on conflict of interest, which is in any case incorporated under our Arbitration and Conciliation Act. IBA guidelines on taking of evidence. Now, this is one very important soft law, and in almost 60%, as per one study of Queen and Mary, in around 60% cases, international arbitration, parties agreed to be bound by and agreed to be guided by IBA guidelines on taking of evidence. So what is that? Basically, IBA guidelines on taking of evidence tells you how to come out with your witnesses, what will be the how witness statements or evidence by affidavits are to be prepared, how it is to be filed, what is the role of experts, tribunal appointed experts, party appointed experts, cross examination. So it basically streamlines your whole process, and it is a very interesting piece of paper which you must read. Similarly, IBA has various other guidelines. Chartered Institute of Arbitrators UK has various protocols and guidelines on how to write awards, how to grant interest, how to grant cost, how to have role of experts. So these are very important material which you must read, that will really make you aware of the international best practices. Um, in fact, IBA guidelines on taking of evidence is something which we have started using it very frequently in India, in domestic arbitration. Recently, in 2 cases, I have used it, and we have used it, and it is helping both sides, and because you have something to look at when it comes to procedures. Uh, Now, another thing which you should read is exit awards, exit decisions. Now, India is not a party to exit convention. In fact, 2014, I had a lunch with exit Secretary General McKenna, and in the exit headquarters. Basically, exit is headquartered in World Bank's head office in Washington, DC. And she had taken me for a round of the exit premises, and we observed one proceeding, which was one exit convention award of arbitration proceeding, which was going on. Now she said why India is not a signatory to exit convention, though India was one of the first countries who signed became party to the World Bank. So obviously answer is political, and there are other reasons why India is not a signatory to exit, but you should read exit awards and exit orders, and because as arbitration is a confidential proceeding, you don't get to see arbitration awards or arbitration orders, or the submission of pleadings or memorials otherwise. And in another important thing is that in exit arbitration, the stakes are quite high. So quality of arbitrators is again very good. You have world's top class arbitrators sitting as arbitrators. So this is interesting. You get interesting materials to read, so you can access to exit website, and these you just Google and you get everything available on the website. Now, apart from this, you have something called yearbook, which is published by ICCA, which there you will find ICC awards in redacted forms. So all the informations which can connect you to the parties are removed, but you get to see ICC awards. That is another interesting thing. You should read law reports. In India, you have various law reports which publishes arbitration judgments. You should read arbitration journals, good journals like LCIA has its journal. Obviously, it is made available only to their member, and their membership charges are a bit prohibited. Chartered Institute of Arbitrators again publishes its journal, and again it is available to their members only. But there are many other journals which are available for free, which you can just go and Google. Arbitration blogs. There are multiple arbitration blogs, like Kluwer has its own blog. Again, it is freely available. You can just Google it, and you can read interesting reads. Then people ask this question, which book one should refer to? I'll refer three books. You can buy either of the three. One is a book by Gary B. Bourne. Gary's books have two categories. Basically, they have one paperback edition. It is for students. You can refer to that Gary's book. And another book is written by Redfern and Hunter. Again, this is a very popular book taught in law schools, particularly in UK and this part of world. And third book I would recommend is by Margaret L. Moses, which is a Cambridge law publishing house's edition. This is again a good book, and this book is taught and referred in American law schools. So these are the three books you take, like you can go for Redfern and Hunter, and that's good enough. Don't clutter yourself. Don't read too many material here and there. Read one book, take it as a textbook. And before I move ahead, I must tell you that sometimes people say that I am doing arbitration or I want to do arbitration. Now, I don't see myself going in for investment arbitration or international commercial arbitration. Therefore, for me, what should be enough is reading of Arbitration and Conciliation Act and any book on Arbitration and Conciliation Act, and that should be good enough for me. The question is whether this is enough. My answer is no. If you really want to pursue your career in arbitration, then never ever confine yourself to domestic arbitration only. And this is for more than one reason. First of all, arbitration is arbitration. You start doing arbitration and tomorrow you get an opportunity for international commercial arbitration. You cannot refuse by saying that I do only domestic arbitration. That is one, and you should not. Secondly, even in domestic arbitration now, things have changed substantially, and international best practices have made inroads in domestic arbitration as well. Like invariably, like I just said, use of IBA guidelines on taking of evidence. Suppose you are representing one of the parties in an arbitration, and the other side lawyer says that let us go by IBA guidelines on taking of evidence, and tribunal says yes. What will you say? Will you say that I do not know about this because I do only domestic arbitration? I have never heard about it. That's not done. Similarly, and one thing we should realize that arbitration is different breed of animal. It is not replica of court litigation. Sometimes one get to one feel that since I am a good litigator, I know civil procedures and evidence act well, therefore I can be a good candidate to sit as arbitrator, or I can be a good arbitration counsel. I'm sorry. First of all, clients in the disputing parties will goes to only those for if the client has to choose a lawyer for his arbitration or arbitration, he will not go to a good litigator. Just because you are a good litigator, client is not going to approach you. Client will approach only those people who are well aware with the arbitration laws and arbitration procedures. So you should equip yourself with this. Another important aspect is that arbitration and international commercial arbitration now follow a mix of and hybrid of the procedures in different legal cultures. Now, in international commercial arbitration, what you see these days is a lot of importance is given on written advocacy, written briefs, written submissions. What is that? This is essentially the tradition of civil law cultures. Continental Europe, countries in continental Europe, in fact, Latin America, all of it. Japan is a civil law country, even the closest in your neighborhood, Nepal is a civil law country. So in all civil law countries, written advocacy, they give a lot of importance to written advocacy. Now, however, now in international commercial arbitration as well as in domestic arbitration, you will see that a lot of importance is being given to written advocacy. Now, though we follow written advocacy largely in arbitration, but at the same time, oral advocacy, which is essentially oral arguments, oral submissions, or cross-examination, which is influenced with basically in common law countries and common law culture, we go by this. For us, no proceeding is complete unless we get oral hearing, and it's a lot of emphasis on oral advocacy. Now, this is influenced by this is influence of common law culture, common law legal culture. Now, in arbitration, on the one hand, we follow the written advocacy, but at the same time, we retain the common law influence of oral advocacy, cross-examination. Now, like discovery. Now, discovery is one thing which is again very commonly used in common law countries, but in civil law countries, they really don't go for discovery. Like they really they look at with distaste so far as cross-examination is concerned. In civil law countries, they do not do cross-exam. They do not go for generally do not go for cross-examination. If at all they go for cross-examination, that cross-examination will be conducted by the decision maker, the arbitrator, or the judges. And if at all that cross-examination happens, generally they will not have leading questions. Unlike in common law country, here in common law country, first lesson we learn in law school is in cross-examination, you should always ask leading questions, the closed questions. Whereas in civil law jurisdiction, they always go for open questions. Now, there are reasons for that, why they strongly believe in what they do. Now, question is, if you really want to do arbitration, domestic and international arbitration, you must know all these cultures. You must know the peculiarities and attributes of all these cultures. You may have a tribunal where you may have one arbitrator from common law culture, another co-arbitrator from civil law culture, third arbitrator may be from Sharia law culture. Now, as an arbitration professional, you will have to understand their legal background, their cultural background, because they would expect what they have been practicing. So a good lawyer, good arbitration lawyer tries to step into the shoes of the arbitrator to understand what are the expectations that particular arbitrator has. Now, there have been instances where lawyers from common law countries have been found in a very awkward situation because the chairman is from civil law culture, and something which is very common in common law culture is not at all common in civil law culture. So you must know all these cultural issues. Now, one thing which is generally asked is that a particular law, it's very common question that Section 19 of Arbitration and Conciliation Act says that CPC and Evidence Act doesn't apply in arbitration. So, should we read CPC and Evidence Act or no? I would say you should read CPC, you should read Evidence Act, because you get to see, because see, there are two regions for this. One, Arbitration and Conciliation Act will not teach you, and it has got no provision to tell you how a particular pleading is drafted, how a defense is drafted. So you should refer to CPC, you should refer to rules of evidence. If you are practicing in court, it helps you. Now question is, how to, if Arbitration and Conciliation Act says CPC and Evidence Act doesn't apply, should I close my eyes to CPC and Evidence Act? No, you should not. Unless you know what is CPC, unless you know what is Evidence Act, what are the rules of Evidence Act, how will you know what doesn't apply? But in arbitration, basically what happens is that arbitrators or the parties with agreement devise their own procedures as per the requirement of the case. I'll just give one interesting aspect to it. There is one CPC which applies to all litigations all across the country with regard to all kinds of civil disputes, irrespective of the nature, quantum involved, and everything. Now, a particular litigation in court, for a particular litigation in court, court is not going to tailor make the procedures which will suit that particular dispute. But in arbitration, you have got that freedom. You know what is needed for that arbitration. You devise that procedure and go ahead with it. Another thing is, very common questions from lawyers as well as senior level people and the law students as well. How to get into, how to break into this arbitration community and arbitration world? Answer is that try to attend as many conferences and seminars and workshops you can. There you get to learn the subject from the experienced people, and apart from that, it makes you visible. You get to meet people, and that visibility helps you. In fact, whenever you get opportunity to speak on any aspect of arbitration, you must speak on that. Now, another question sometimes comes from law students is whether we should do LLM in ADR or alternate dispute resolution. I would say yes, LLM helps, but try, if you go for LLM after a couple of years of practice, that is better. Now, another thing is there are lots of short-term courses which are being conducted. Hague Academy of Law does 1 month course. There are many organizations, institutions, they will have short-term courses. You should look at that as well. Try to become member of arbitration institutions, various arbitrations institutions all across the globe. That really helps you. LCIAA has got young membership. FCIArb, Chartered Institute of Arbitrators, has got young membership. ICA has got young membership. So this is again very interesting things. In fact, I would encourage all of you, whenever you travel abroad, go and see the arbitration institutions. If you have gone to Singapore, try to go to Maxwell Chambers. If you are in London, visit LCIA. If you are in London, go and see a Chartered Institute of Arbitrators. That gives you some exposure. It helps. go to the law libraries of wherever you go and see what kind of books are available in those libraries on arbitration. In fact, a good arbitration professional knows good books on arbitration written anywhere in world. So try to create a good library on that. In fact, I'll give one I'll give one database of all the uh, links of various institutions, various organizations which can be accessed for interesting material. So I'll give this to the organizers and they will circulate amongst all of you. Now question is how to start your career. In law schools, when you are in law schools, try to do mooting, or if you are in engineering colleges, see if, I don't know, engineering colleges, they will not have this kind of opportunity, but law schools, yes. Try to go for, there's some very popular moot competitions, like Wish Vienna, Wish East in Hong Kong. In fact, I have been judging them for long now. So participate in moot courts. You have a lot of moot courts happening in India as well. Develop this habit of writing for journals. You can write blogs wherever you can write. Uh, Clerkship or internship or juniorship with arbitration professionals, and try to work with people who are doing the international arbitration. That helps in better way. Dual qualified professionals get some age and advantage because, and it is a trend. So a lot of people who are having dual qualification, they get some age. In fact, there is another trend I must share with all of you, that lots of arbitration professionals are also increasingly getting into mediation. So this is another career option. Obviously, mediation is a standalone career option. One must admit that. But lots of arbitration professionals are, in fact, now invariably every second good arbitrator is doing a good amount of mediation. And last thing on this, how to start your career would be, try to find out a mentor. That will help you in big way. Now, how to further your career in arbitration and how to make it sustainable? I would say training, training, and training. Training is answer to all. Try to go for conferences, seminars, training programs. Attend as many as you can. Keep yourself updated with latest developments in international arbitration world. Now, there is another thing, attributes of arbitration professionals, what is again very important aspect. Knowledge of arbitration law, knowledge of arbitration procedures, domestic, international, investment, knowledge of commercial law. In fact, this is an era of specialization. So in arbitration also, there are various subsets. Like I do lots of construction arbitration, lots of joint venture arbitration. Now, there are people who do sports arbitration. You have people who are doing oil and gas. You have people who are doing maritime arbitration. So this specialization also helps. You will be recognized by, because why this specialization? Because arbitration essentially, in arbitration, what clients would look at is that not only your knowledge about the arbitration as a subject, but how well versed you are with that particular industry. So the domain knowledge is again very important. So you should start. In fact, in India, in my estimation, if you see big arbitrations, good arbitrations, around 60% are construction arbitration. Only thing is, in fact, uh, 6-7 months back, I was speaking in a conference in Singapore, and I was asked 3 questions. One, do you have construction law being taught in law colleges and engineering colleges? Second was, do you have construction law legislations in India? And third was, do you have construction technology and construction courts in India? An answer to all the three was no, we don't have. But still, maximum number of arbitration are in construction, relating to construction disputes. So you will have to take extra interest in order to acquaint yourself with the knowledge of this industry. And in fact, tomorrow I am talking about this construction, some of the aspects of construction dispute in a webinar organized by Nishit Desai. Now, attributes of arbitration professionals, that is another thing which we are talking about. Advocacy skills, this is very important. Ethical values, again, ethical values, you have lots of literature on this. You have lots of protocols on this. So we should be careful about the one thing which I must talk about. The biggest name in arbitration in Singapore is Michael Wong. He retired as a judge in Singapore. He started his career, and in his he has published a compilation of his essays, which are freely available on websites. You can read that. In this essays by Michael Wong, and in that, in the introduction itself, he writes, he says, I wanted to talk about my journey as arbitrator. He says, when I retired as a judge, I started unlearning many things, particularly procedure aspect, which I learned as a judge. And obviously, you're not supposed to unlearn everything. Decision making is something which is again very important for any arbitrator. So you are not supposed to unlearn the decision making abilities, but procedural aspects, a lot of aspects related to procedure and arbitration are to be unlearned. This is what he says. And then he said, I went to have accreditation of Chartered Institute of Arbitrators, London, and he became fellow of the Chartered Institute of Arbitrators, London. I'll talk about this Chartered Institute of Arbitrators in a bit, in a while. Now he said, then he underwent training program in Paris, the training program organized by ICC. He said he went to HKIC to learn the rules of HKIC and as well as having a training. So he said he worked for a couple of years upon himself to acquaint himself with the arbitration world, the best practices, ethical practices, and all of this. So this is one thing we should look at. Now, we should also know about the something called guerrilla tactics. Every arbitrator and every lawyer knows, because there are lots of technical issues which crop up if we are in conduct of arbitration proceedings. So one should know. I'm not saying that you should apply this, because guerrilla tactics is something which is unethical. So I'm not saying that you should use them, but you should know. And there is a very interesting book on guerrilla tactics which runs into around 400 pages. So there you will get to know how to take care of the surprises which can be brought before you by your opponents in your arbitration. And I'll end up by.
So there's a connected question there. I'll just interrupt in between. So there's a question, specific question you've received. In your experience, what special skills should a lawyer generally possess in arbitration? So I believe guerrilla tactics is one.
A skill, I'll tell you. Yeah, a skill, when it comes to a skill, you should work on your written advocacy, how to draft pleadings. That is very important, because as I said, written advocacy is given a lot of importance. So written advocacy, you should know how to make your submissions in arbitration. You should be soft. You should not be very harsh. This is not tough lawyering as you do in courts, and so it is basically soft lawyering in arbitration. You should be good in communicating, and so that you can communicate well. A very important thing is that the tribunal must have faith in you. So that is what you have to develop, so that you can do hand holding for the tribunal. Whenever tribunal has any issue, any query, any confusion, tribunal should look at you as the reliable hand holder. You are not supposed to just take the tribunal to the jungle of facts and jungle of laws and leave them there. So you should give them solution. You should be honest to the tribunal. Ethical values are something which are very, very important. And you should know international best practices. You should know how to address the tribunal. Now, in India, though we address the tribunal members, honorable judges, as my lords in arbitrations also, but in international arbitration, you are not supposed to address them as my lords. There you address them as Mr. Chairman, sir, Mr. So-and-so, whatever his name is. And this is how it works. You should not do gesturing like you do here in courts. And you should know the culture of the arbitrator. For that, you are supposed to know the legal culture of the particular jurisdiction from which this particular gentleman is coming. So these are some of the skills set you should have, or you should possess.
Okay, sir.
Yeah.
Yes, sir. So please continue, sir.
Now, one thing, very commonly asked question is, should we go for any accreditation? In fact, now our Arbitration and Conciliation Act amendment, which is amendment of 2019, also talks about accreditation. The accreditation by arbitration institutions and all. But on global level, the most recognized accreditation is of Chartered Institute of Arbitrators, London, UK. Their accreditation is gold standard, and their accreditation is globally recognized. If you are a fellow of Chartered Institute of Arbitrators, you can use this suffix after your name, FCIArb. Like you may have found after my name this suffix. Now, once you have this suffix, you don't need any introduction anywhere in world so far as arbitration community is concerned. Everybody would get to know that you know the subject. You know, you don't need any other introduction. So there are other accreditation, like Prime Disputes UK gives accreditation. Malaysian Institute of Arbitrators give accreditation. Singapore Institute of Arbitration also gives, there are some institutions in Singapore also, they give accreditation. So you should go for accreditation. If you have accreditation of Chartered Institute of Arbitrators UK, you become eligible to be on the panel of arbitrators of many arbitration institutions. This is very, very important. And how do you get that accreditation? For that, you have 3 tier of accreditations. One is associate grade. Thereafter comes the membership grade, and third is the fellowship grade. For that, you have courses. Like for associate grade, you have 2 days course. For membership, you have 3-4 days course. Like these courses, you have to undergo courses, write exams, and all the exams have been conducted by the FCIArb headquarters in London. In fact, I have been in charge of doing these FCIArb accreditation programs in India for Northern India. So after lockdown, soon you will get to hear anybody having interest in these accreditations about this. And there you will have only accredited tutors. They will be teaching you arbitration. So these were some of the aspects. Now I see time is up. It is 5:36. So I'll conclude my talk here, and I'm ready to take questions if you have any.
Yes, sir. So there are some questions. I'll ask the first one. So what is the fundamental difference you've experienced in international arbitration and domestic arbitration? How easy is it to do online international arbitration? And is it common?
So far as difference between international and domestic arbitration is this. In international arbitration, the law which may apply can be many. For if you have dispute about, like I'll tell you, we can explain it like this. The law, governing law, which governs the substantive rights and obligations of the parties can be one. Let us take this example of the arbitration I talked about, which is going on in Japan. Now, there the governing law which will determine the rights and obligations of the parties of India. However, the arbitration law, the lex arbitrae, will be of Japan. Now, in this case, another issue arose. What would be the law applicable to the arbitration agreement? These are distinct laws. Law relating to arbitration agreement can be different from law governing the rights and obligations of the parties. And the third is the lex arbitrae, the arbitration law of the country where arbitration is being conducted. So these are all 3 different laws.
Right, sir.
Now, the arbitrators, if it is institutional arbitration, the arbitrators chairman will be from a neutral country. He will not be from the country of either of the parties. You have different legal cultures. You have application of private international law in certain disputes. So these are the peculiarities and attributes of international commercial arbitration. Yes.
So, and the other part of the question was, how easy is it to do online international arbitration, and is it common these days?
Online, see, this is a very, I would say, for me, it is an enigma, the online ODR. First of all, invariably in international commercial arbitration, parties will assemble for personal hearing only for, generally, I would say, for the hearing. Hearing means cross-examination, examination in chief, cross-examination, and the oral arguments. Rest all is being managed through electronic means. Everything is being done through electronic means. And only, in fact, I was doing one arbitration in London. There I had to cross-examine 4 witnesses, and one of the witnesses was sitting in Melbourne. So we did it through video conferencing. I cross-examined him through video conference. Obviously, there are protocols how to cross-examine a witness through video conference when he is sitting in some at some other place, because you may have a apprehension that that person may be tutor, maybe tutored by somebody, or he may be. So what we do is, there will be mechanism, there is some housekeeping exercise will be done. That person must be administered oath by some notary at local level or somebody else, and thereafter we ensure that this person is not being tutored. So there are certain protocols to take care of this, and in fact FCIArb has also come out with the protocol on this. Now ODR, so this is very common in international commercial arbitration. Physical hearings only happen for very important thing. It is not done the way we do it here in India, that for every big and small thing we sit for physical hearing. It doesn't happen. So far as ODR as a concept is concerned, that is a different concept. ODR is a concept where the entire arbitration happens without any physical presence, and so that is a different concept altogether. Yeah.
So there's a related question. So in an online arbitration, how safe is it to do cross-examination of a witness? And is there a chance of witness being tutored? And how to ensure that in an online arbitration, witness is not tutored when any question is put?
Actually, what happens, the lawyer or the person, this person obviously will be administered oath, and so that person is under oath, or you can ensure it by having a notary. That person may be asked to sit with a notary, and that notary says that I'm here and I vouch for this, or he can be asked to sit in some consulate. So there are ways to take care of this, that this person is not being tutored, and you can have full view of the room, so that you can understand what is going on there. Now you have lots of good technology which takes care of this. Yes.
So I'll move on to the next question. In case of international commercial arbitration, what is the scope of the same in India, and what firms are to be so referred? So for international commercial arbitrations, what are the leading law firms in Indian parlance, and what is its scope in India?
See, all top tier law firms are doing international arbitrations. Lots of boutique firms are doing international arbitrations. So you can go on their websites. See, difficulty is that lot of law firms, lot of law offices claim that they do arbitration, but what they do is they do not have international arbitration or international commercial arbitration. So if somebody wants to really train himself or herself for arbitration, they should try to go to places where international arbitration also happens.
Okay, sir. So next question is, how important is pleadings in international arbitration?
As I said, that written advocacy is very important. So written pleadings, the pleadings in writing, that is the very important, because at the time of passing of the award, what remains with the arbitration tribunal, apart from the hearing notes, is the written pleadings. So you must develop this art of writing good pleadings, the simple English, plain language, small sentences, small paragraphs. You should be good as storyteller. You should be in a position to write your whole case in one paragraph, gist of this. So you should be a good storyteller, and you must know the formats and structure for writing of all of this. So that is very important. In fact, soon I'm writing a book. Soon you will have a book which will have all the forms for entire arbitration process, starting from notice to arbitration and everything. Yeah.
I'm sure it'll be quite helpful for all the students and practitioners.
Let us hope so.
Yes,
yeah,
sir.
Let us hope so.
The next question is, how are documents exhibited, that is primary or secondary, and how are the veracity of a document established?
See, first of all, there is nothing called primary and secondary evidence in international arbitration or good arbitration. What happens in arbitration, international arbitration primarily, we have something called procedural order number 1. that is in the very beginning of arbitration, very detailed order is prepared by the arbitration tribunal, which takes care of all the procedural aspects. This gives you roadmap for entire arbitration. And in the procedural order itself, generally, I would say, it is written that parties will be filing all documents in photocopies. And if other side is really having any issue with regard to authenticity of a particular document, then he can raise that issue. And secondly, in international commercial arbitration, generally, arbitrators will say all documents will be deemed to have been admitted until unless a particular document is specifically being denied. That's it. So that takes care of everything. Yes.
So the next question is, for a lawyer not practicing in a metro or big city, how can they venture into international arbitration? And how is mediation different from arbitration?
See, if you are practicing in smaller cities, first thing is go to trial courts. If you really want to become good arbitration professional, start your career as a civil lawyer, trial lawyer, go to courts, observe as many trials you can, as many cross examinations you can, write as many pleadings you can. That helps you in big way. And thereafter, so first you have to create that infrastructure for yourself. Read all the material which people are, I have just discussed. Create that infrastructure for yourself. Equip yourself with that knowledge. And once that happens, thereafter, you can make yourself visible. This is a world of now. You can start writing articles, you can start writing papers, you can start speaking in events. In fact, I know one gentleman who is doing quite well these days. He is operating from not only tier 2, rather tier 3 city, very smaller city, and he's very visible in arbitration world in India. So it is not that it is a handicap. Yes.
So how are international arbitration awards enforced?
Actually, there is something called New York Convention. So all the countries which are parties to this, in fact, if you read part 2 and schedule 1, that is New York Convention only. So this is a New York Convention. All countries which are parties to this particular convention are bound to enforce the awards given in any convention country. And as of now, you have around 158 countries. All trading countries are parties to this New York Convention. So suppose you have an award passed in Singapore, and that is to be enforced in India. Now Singapore is convention country, means it is signatory to the UN convention, New York Convention. Similarly, India is signatory. So award will be enforced in India. Suppose an award is passed in India, it is to be enforced in Singapore. You can enforce this in Singapore. Yes.
Thank you, sir. So the next question
one thing I must point out. See, there are a lot of questions sometimes about what is international arbitration and this enforcement, where enforcement happens, where award is passed, and all of this. I'll give you very thumb rule. In international commercial arbitration, award is the citizen of the country where award is passed. Citizen, not in that legal sense, just for analogy. So award is citizen of a country where award is passed. Let us dispute was between Indian party and Australian party, and arbitration was seated in Singapore. Seat of arbitration was Singapore. Award is passed in Singapore. So therefore award becomes citizen of that Singapore. Now, where can you challenge that? You can challenge in the country of which that award is a citizen. So this is how you can remember it. So award can be challenged only in the country where that award is passed. And where can you enforce? You can enforce the award anywhere in world wherever you find assets of the award debtor is lying. Right? In fact, there are certain jurisdictions in world which recognize, enforces the award even if it has been set aside by the competent court. India doesn't do it. France does it. Various states of US does it. Many other European country does it. And for that they have different philosophical regions. Let us not go into that. That's not the topic. Yes.
So next question is whether bringing Arbitration Council of India can become an impediment to the free arbitration.
No, I'll say it. No. Why arbitration was not very successful in India was because ad hocism in arbitration in India. Ad hocism had led to a situation where there was no accountability either on the part of the lawyers or on the part of the arbitrators. Proceedings were going on for years and years and years. So institutionalization of arbitration in India is a very good step, and I think it is a need of the hour. See, that doesn't mean. Yes. Yes,
sir.
next question. Yes,
sir. So while conducting expedited arbitration, how are the principles of natural justice ensured?
See, expedited arbitration. See, I'll tell you this principle of natural justice, this due process issue. In fact, there are a lot of literature on this, that due process paranoia. See, expedited procedure, as mentioned in your Arbitration Conciliation Act also, is essentially about the autonomy of parties, what parties agree with each other. And just because you do not have very detailed procedure, so long as you are able to plead your case, that should be enough. So there is no principle of natural justice violation. Ultimately, it is about autonomy of parties.
Okay, sir. So can you give a brief idea about bilateral investment treaty arbitrations?
Do we really need to go for BITs? See, bilateral investment treaty, I'll tell you, one interesting aspect about BITs, when you talk about arbitration, first thing you learn in your law school is that in order to have arbitration, you must have an arbitration agreement, because arbitration is creature of arbitration agreement. Your Arbitration and Conciliation Act also says, Section 7 also says that you must have a arbitration agreement. But there is one exception to it, and that exception is these kind of investment treaties, bilateral treaties or other regional treaties. So there, the treaty is, signatories to the treaties are nation. So country states sign the treaties. But here, any citizen from that country can sue, means can invoke arbitration against the other country, host country. So that is one interesting aspect. Basically, the BITs, bilateral investment treaties, have been now recently revised in big way by the Indian government because of certain awards which India suffered, like white industries case. And now India is facing a lot of other investment arbitrations. Investment arbitrations has again got its own peculiarities. Anybody who wants to pursue investment arbitration or has got interest in investment arbitration, what he or she should do is they should start taking bit extra interest in public international law, because a lot of principles of public international law has its application when it comes to BITs. So basically, whole idea is that if you have two countries entering into this kind of treaty, the citizen from or organizations from one country should not get any unfair treatment in the another country, and there are basic triple test and all. So that would be very lengthy argument. So in sum and summary, now in fact people think that unless you give this kind of protection to the people from investing countries, they will not be in a position, they will not get you investment and all that. I don't think that is a very well-founded thing, but that is a different nature. Yeah. Next. Anything else?
Last question is how can an ICA award be challenged, and at what forum?
ICA means Indian Council of Arbitration Award. Hello? ICA means Indian Council of Arbitration Award.
Yes, sir. Yes, sir.
Indian Council of Arbitration.
Yes,
Indian Council of Arbitration Award would be an award in a domestic award. So it would be challenged the way any domestic award is challenged.
Okay, sir.
Anything else?
So that's it, sir. Thank you so much, sir.
Okay,
over to
thank you very much.
I think these are the questions that we have. I think my connection is bad.
I can hear you. I can hear you.
Okay. Sometimes it is. So thank you very much, Mr. Singh. It's been a really insightful journey into the arbitration, and I think a lot of our viewers must have really liked and must have a lot of questions what they had probably been answered by your talk. Thank you very much. Thank you very much.
Thank you. Thank you.
Thank you so much, sir.